for that introduction and for giving me the opportunity to speak today. As Professor Gravy mentioned, I have a background as a legal aid lawyer and a consumer rights lawyer, so my interest in Medicaid expansion initially started as a frontline interest. New Hampshire Legal Assistance, where I used to work, is the state's only statewide legal services organization. So New Hampshire Legal Assistance represents low-income and working poor clients in essential matters for everyday survival, including benefits law. And so a lot of the families I worked with when I handled my education cases were either seeking or receiving or suffering from termination of government benefits in various forms. So I followed Medicaid expansion very closely because of how it was going to affect and has affected the types of clients that I worked with when I was a legal aid lawyer. Then, being a legal academic, I inevitably got curious about the policy and constitutional law issues. So I'm here today to provide an overview, as Professor Gravy said, of the background issues here, and then we'll hear more from two very distinguished experts in the field. The title for my presentation really could be, much more simply put, when does a carrot become a stick? And it will proceed in, this will make a little more sense to you in just a moment, but keep that in mind as we continue our discussion. It will proceed in three parts. We're first going to take a look at the fundamentals of congressional spending power. Where in the Constitution does it say that Congress can do this? What are the constitutional limits on Congress's ability to do this? Next, we'll focus in on the Supreme Court's decision about Medicaid expansion in the Affordable Care Act case. And then last, but certainly not least, we'll take a very brief overview of the landscape of Medicaid expansion as it stands right now, using New Hampshire as a bit of a case study because, hey, we're here. So turning now to congressional spending power and the basics. As you've heard already today, the powers of the federal government are limited and enumerated, not general. So if the federal government, in this case Congress, is up to something, it better have a place in the Constitution where it can stick its finger, not the original Constitution, but copy, and say, this says I'm allowed to do this. And for congressional spending, we're looking at Article 1, Section 8, which empowers Congress to spend money on behalf of the general welfare of the United States. And we know from the way that the Supreme Court has interpreted Article 1, Section 8 over time that this means Congress can authorize the expenditure of public monies for public purposes. One category of public purposes for which it may spend money is to establish cooperative federal-state spending programs. So in other words, Congress can say to the states, we'll make you a grant. We'll give you X amount of money if you do Y and Z things, right? Because, hey, it's the government. It's not going to just hand over a boatload of money and say, do whatever you want to with it. So for those of you who are sort of more history buffs, the big case here that established the contours of the ability of Congress to spend money on these cooperative programs was United States versus Butler back in 1936. Before this case, it wasn't clear whether Congress could spend money in pursuit of the general welfare of the United States, or whether this clause only was tied to other parts of the Constitution, other enumerated powers, and meant that Congress could spend money for the general welfare if the general welfare meant another enumerated power in the Constitution. And the court eventually went with Hamilton's view rather than Madison's. They've been fighting about this for a little bit and said this is a freestanding provision. So Congress is okay spending money in pursuit of the general welfare, including these cooperative federal state grant programs. And Congress took that ball and ran with it. Federal spending on grants to state and local governments grew very rapidly over the course of the 20th and 21st centuries following the Butler decision. By 2010, federal spending on state and local governments was over $608 billion, which is roughly 38% of state and local expenditures. So to say that again, roughly 38% of the money that our state and local governments spend on us and our fellow residents is actually coming from the federal government. That is big business. The question is, when is it too big to fail? Well, sometimes it's not too big to fail. And we'll get to that, as Professor Graby alluded to in the Affordable Care Act decision. But before we get to that example, so as I mentioned a moment ago, Congress seldom, if ever, is just going to hand the states a lot of money and say, go have fun with this, don't spend it all in one place, or we don't care. There are going to be strings attached. And the Supreme Court has said, interpreting Article 1, Section 8, that strings can be attached to further broad policy objectives of the federal government by conditioning the receipt of federal monies on the compliance of the recipient, in this case the state, with federal statutory and regulatory directives. So the federal government can attach some strings. The question is, to what extent can they attach those strings? And the concern underlying the extent to which strings can be attached gets back to these fundamental issues of federalism. The United States Supreme Court said, actually in the Affordable Care Act case, that not to limit the ability of Congress to impose strings would, quote, present a grave threat to the system of federalism created by our Constitution. Why is that? Well, in some ways it's a numbers game. The federal government has a lot more money in its coffers than any individual state does. So if it had the ability to make states offers that they couldn't refuse, right, with all these conditions, then all of a sudden you have the federal government usurping the making of law and regulation in sensitive areas like criminal and family law that are typically the province of the states. Even more fundamentally, then, this becomes a question of democratic participation. When we vote for our state officials, they're going to answer to us, right? And only us, the residents of the state. Well, though, if they're essentially on the federal government's payroll and answering to these conditions that they can't refuse, they stop answering to us, and instead they're answering to the federal government and citizens nationwide who elect the federal government. So this is, again, sort of the animating concern, one of them, of federalism that underlies the Supreme Court's keeping a very close eye on the strings that Congress can attach to the grants it makes to the states. And just a quick visual here, because I find that usually helps me. If it will come up. Okay, here we go. So right here we have a very pretty picture that I take absolutely no credit for of the powers that Congress gets from the Constitution. Over here you see the spending power, and it's giving you a little preview of what I'm about to go into more detail on. So Congress can spend for the general welfare. It can have these cooperative state, federal spending programs, but these are the limits on Congress's ability to attach strings to the money it gives to states. The conditions that it's imposing on the grants to states have to be unambiguous. They have to be germane to the federal interests in the program. They can't force states to violate other provisions of the Constitution, and they cannot be coercive. Throughout our discussion today, you will hear reference to all of these different limits. The one that we'll talk about most with respect, at least to the Affordable Care Act decision, is when is it actually coercive for Congress to attach a particular condition? How do you know when coercion is happening? So before the Affordable Care Act decision, back in the late 80s, one of the most high profile, if not the most high profile case the Supreme Court had heard under Article 1, Section 8, related to a federal state cooperative grant program, had to do with booze. South Dakota had a drinking age of 19. Federal government changed the conditions for granting federal highway funds and said, all right, South Dakota, that's fine. You can do that. But if you don't have a drinking age of 21, you're not getting your share of federal state highway funds. And it was a relatively small percentage that was on the table. And so this went to the United States Supreme Court, and we'll take a brief listen to counsel for the government trying to articulate where the boundaries are, right? So we just talked about how there are limits on the ability, constitutional limits on the federal government's ability to impose conditions on state grants. We have a little list. So now we're going to hear one attempt to figure out actually in practice what does that list mean. Spoiler alert, it's really not that straightforward. Okay. Don't worry, we are not listening to the whole thing. Although for people who really want to dork out on Supreme Court arguments, the OIA project is awesome because you can listen to stuff from a long time ago. Okay.
One of the express purposes of federal highway assistance is to promote safe travel. Nevertheless, one of the consequences of this expenditure and the resultant improvement in our highway system is to exacerbate the problem of what President Reagan called blood borders between states. Section 158
Where is it?
is a fundamental chain of safety rules.
Oh, here.
Blood borders problem. It seems to me that it's open to Congress to decide that it doesn't want to provide full federal funding for highways in states where those highways may be used by young persons in lawful quest of alcohol.
Is there some limit then on Congress spending power of a requirement of germaneness or relatedness? Could Congress enact this same kind of a grant attached to, this same kind of condition attached to a grant for school lunch money, for example?
The answer is that the court has frequently said there is some kind of a limit attached to the spending power, and to my knowledge has never said what that limit is.
So that is a very polite way of counsel saying, yeah, you guys have said there's a limit. You really haven't told us when we're going to hit it. And he went on to make the argument that the limits on the ability to attach strings to grants to states, whatever it was, had not been hit in the federal highway program that would have taken away funds from South Dakota. And the court agreed with him. It was a relatively small percentage. It was found not to be coercive. And so, and it was found to be germane to a federal interest in the highways. You heard, as I'm sorry, I was trying to get the volume up, I thought it was, but that the problem was blood borders. You had people who were under 21 but over 18 or 19 driving to a neighboring state to buy alcohol, getting drunk, driving back drunk, and getting into accidents and dying. And so the court's saying, yeah, Congress, that's true. Conditioning federal highway dollars on having a drinking age of 21 is germane to the federal interest there. So now we start to turn to the Affordable Care Act decision to say, okay, we know there are limits out there. We know we're not exactly sure what they are, but we're going to try to figure out if they've been hit when Congress put together the Medicaid expansion component of the Affordable Care Act. So remember the limits that we just talked about. All of these limits will get talked about by the Supreme Court. They're going to talk the most about whether the conditions under Medicaid expansion were coercive. They'll talk a little bit about whether they were unambiguous. So Medicaid without expansion is a program that has an income requirement and provides coverage for selected groups, including pregnant women, families with children, blind, elderly, and disabled. Under the expansion plan in the Affordable Care Act, everyone under 65 in a state who had an income below 133% of the federal poverty line would be entitled to coverage with an essential health benefits package that would cover that person's obligation to have health insurance under the individual mandate. The penalty for noncompliance was that the federal government could take away all of a state's Medicaid funding, even if it kept traditional Medicaid. So just make that very clear. We're saying, okay, states, if you don't do Medicaid expansion the way we've outlined it in the Affordable Care Act, we're taking all your Medicaid funds back, not just the funds that you would have gotten for expansion. So the court, when the Affordable Care Act case came before it in 2012, is really looking at two basic questions. Is the expansion a constitutional use of the spending power? And if not, what's the remedy? the ruling in the Affordable Care Act case initially produced some supreme confusion. I want to be mindful of time, but I do have a link embedded in there to CNN getting the holding in the Affordable Care Act case wrong right off the bat, which many of you probably remember. Looking into it more over the years, I now have increased sympathy because it's very long. And there's a real shifting alignment of justices on the different opinions. So the bottom line takeaway on Medicaid expansion is that Medicaid expansion under the Affordable Care Act is unconstitutional, according to the court, an unconstitutional use of Congress's ability to spend money on cooperative federal state programs because of the conditions it attached. But the court also said the remedy is to sever, to remove the part of the statute that said the federal government could take away all Medicaid funding from the states that refused to expand. The result is that states were left to choose whether to expand their Medicaid programs and get additional funds, or retain their existing Medicaid program but get no additional funds. So very brief snippet of oral argument in the Affordable Care Act case, because it's too good to pass up. We are going to start hearing just a little bit from Justice Kagan. So she starts by saying, the question is, why is a big gift, she's calling it a big gift, Medicaid expansion, from the federal government a matter of coercion? Because at least for the first couple of years under Medicaid expansion, federal government would have picked up the whole tab. So now she's
a big gift from the federal government, a matter of coercion. In other words, the federal government is here saying, we're giving you a boatload of money. There are is no matching funds requirement. There are no extraneous conditions attached to it. It's just a boatload of federal money for you to take and spend on poor people's health care. It doesn't sound coercive to me, I have to tell you.
Well, Justice Kagan, I eventually want to make the point where even if you had a standalone program that just gave 100%, just a 100% boatload, nothing but boatload,
yes,
might still be a problem.
So nothing but boatload. That is counsel for the plaintiffs in the case who are opposing the Affordable Care Act, kind of stumbling over his words because Justice Kagan is giving him a very hard question, right? For the first couple of years at least, you're just getting this money. The federal government's paying for all of it. You just have to use it to give poor people, like the clients I used to represent, health care. And interestingly, Justice Kagan is making it sound like she's very much in favor of finding that Medicaid expansion is constitutional. Well, that's not how it breaks down in the end. She's pushing him to test his responses, and she ultimately signs on to the opinion that Roberts writes that says, and I'll quote, that it is a gun to the head of the states to tell them if you don't expand, we take away all your Medicaid funding, that there's no meaningful choice there, that it is coercive. In an opinion written by Justice Scalia, in which 3 other justices joined, says the same thing in essence. It analogizes federal-state cooperative grant agreements to contracts and says just as contracts are voidable if they're coerced, it is coercive here to say we will take away all this money. For context, the average state, their Medicaid subsidy from the federal government was equal to more than 1/5 of that state's budget. So we are talking, as Justice Kagan, actually to use her phrase, about a boatload of money. And states, between federal dollars and state dollars, devote a larger percentage of their budgets to Medicaid than any other item in the budget. Compare that to South Dakota, in the case we heard a moment ago. The federal funding they would have lost if they did not raise the drinking age was less than 1/5% of their state expenditures. So you have here 5 justices saying, we're not sure exactly where the line is between choice and coercion, between a carrot and a stick. But we know that it is somewhere, right? Once you start getting up to 1/5 of a state budget, that's coercive. In contrast, you have 2 dissenters, in an opinion by Justice Ginsburg, saying that Medicaid's a prototypical example of federal-state cooperation And she goes through the various factors and concludes that it was not coercive, the conditions were unambiguous, etc. But there's here 7 votes, as Professor Graby said, to hold that it's unconstitutional. So the question becomes, what's the remedy? Well, now you have a shifting alignment of justices. Again, why I now have more sympathy for CNN and I think Fox News for getting it wrong, because it is hard to parse. You have Roberts, Breyer, and Kagan saying the remedy is to sever the penalty for not expanding. In other words, Medicaid expansion can go forward, but it has to be optional. States can't have all of their Medicaid funding yanked if they don't expand, but if they don't expand, they just don't get the money for expansion. That's what happens. And Ginsburg and Sotomayor kind of grudgingly agree, saying we think it's constitutional, but if you're telling us it's not, then the remedy is just to remove this part of it. There's a very vigorous dissent by Scalia and his crew saying that this remedy is not constitutional and actually starts to disturb federalism for other reasons that I won't get into for too long, being mindful of time, but essentially saying that you have a separation of powers problem at the federal level where the court is now substituting its judgment for Congress's, which disturbs, in turn, federal-state balance of power. So now turning very briefly to the policy debate that has played out in the states ever since they were told a couple of years back that this was optional. This is a map of Medicaid expansion today. So the dark blue is implementing the expansion, 28 states including DC. Open debate in a couple of states, and then not moving forward at this time in orange. I will confess that I have not yet begun to parse what the results of the election on Tuesday may mean for this, but I will flag that Medicaid expansion as a policy issue does not always break down in conventional political lines. So a lot of the policy concerns in play have to do, again, with states' rights versus federal government, with individual responsibility for something like healthcare versus state responsibility, has to do with balance of power between different actors within a state system, between hospitals, individuals, the government, and so on. Also has to do with business interests. You have some very powerful business interests in a lot of states, including our own, that are very much in favor of Medicaid expansion because it gets more coverage that they are not paying for. So in New Hampshire, as well as in many other places that have gone forward with expansion, it actually has been a bipartisan solution. So who knows exactly what is going to happen after the election. The New York Times did recently find that if expansion had happened everywhere, in other words, if the Supreme Court had come out differently and said all states have to expand Medicaid, or if every state voluntarily chose to do it, about 3 million more people would be covered right now than currently are. So you here see a little sample in New Hampshire of how those big picture policy questions about whether something should be a government responsibility versus an individual or a business responsibility, personal responsibility, etc., are playing out in the advocacy arena. The pro-expansion team in New Hampshire is saying expansion's good for families, so there's a principled reason to do this. It's fair. There's also a pragmatic reason. It's good for the economy. More people have health insurance. They'll get preventive care. They won't miss work. Against expansion, you have people saying the government's going to do a bad job of this, which is a pragmatic point. There's also a deeper federalism point embedded in this, which is what the heck is the federal government doing coming in and implementing, requiring us to implement this type of healthcare program. New Hampshire did become the 26th state to expand Medicaid a few months ago. We're expected to have 50,000 residents enroll. So far, we've had about 20,000. You now qualify for coverage under Medicaid expansion if you're younger than 65 and have an income less than or equal to 138% of the federal poverty guidelines. So those traditional categories that you needed to fit into, pregnant, disabled, etc., don't apply to the expanded population. But it's not that simple. So going back to the idea that federal-state cooperative programs are something akin to a contract, you could say that the contract negotiation here in New Hampshire is ongoing, because what we did here was okay expanded Medicaid with a sunset provision of January 1st, 2016, unless by January 1st, 2016, we have a waiver in place from the federal government that allows us to take those federal dollars for Medicaid expansion, give them to recipients who qualify under expansion, and let those recipients buy coverage in the marketplace. And so there are a number of hurdles that have to be cleared for that to happen. I'm happy to talk about those more in Q&A, but the sort of bottom line with New Hampshire and many other states is stay tuned, because this discussion's not over yet, nor is it over yet here. So with that, I'll turn it over.
Get the, how do I cover the whole screen?
Bottom row, right next to that little slider on the bottom.
Right here?
No, the little red bar on the bottom.
This guy right there? Well, all right. Which is the,
Why PowerPoint's unconstitutional.
thank you. Thank you. Okay, it's not quite unconstitutional, it's just in the feeble hands of law professor. I'm Jim Blumstein from Vanderbilt. Appreciate the nice introduction. That was always nice to come away from your own home institution, because it's always nice to be over-introduced, so thank you. I appreciate that. I want to thank John Graby and Deli Champagne for setting this up, for inviting me to be here, the Peterson Foundation for supporting this, and Leah Plunkett for putting forth a very, very nice and succinct explanation of how the framework in which this issue was discussed and litigated. Although I will say she did leave me a little room to run, because she didn't mention much about the clear notice rule, which I view as the most important part of the NFIB case. It's really wonderful to be in a different audience. Every once in a while, law professors are invited out to speak to polyglot audiences, and since Nicole and I both do healthcare and constitutional law, we learn to speak with different audiences. And I remember a time about important to get your vocabulary right, your framework right, and so forth. And some years ago, the Lord Chief Justice of the United Kingdom was visiting at Vanderbilt, and he told this story, which he said was true. I don't know if it's true or not, but it makes a good story. And that they were trying to get a little bit of a sense of the demographics of the courts in Great Britain. And they sent down a questionnaire, and one of the questions was, please list the members of your court broken down by sex. And the chief judge of one of the districts sent back an answer to the questionnaire on this question, said, puzzled by question. 2 members of the court broken down by age, 3 broken down by alcohol, none broken down by sex. So you need to have a certain common vocabulary and a common understanding about how you're proceeding. So I hopefully I will achieve that. I want to start with discussion first about the role of states in the implementation of the Affordable Care Act. This is really one of the stories that has developed over time, and it's in the process of developing even further with the Supreme Court's grant yesterday of cert in the case that John talked about. It turns out that the states are playing a very important and even fundamental role as gatekeepers. As a result of the NFIB decision that Leah talked about, the states are really now the gatekeepers for expanding Medicaid, and just about half, it's just over half, are expanding, and just under half have not, at least not yet, expanded. I think there will be more expansions. And I think the last election is going to increase in a funky way the expansions because I think the feds are going to be a little more flexible and allow the states to have a kind of a Tennessee plan and so forth to expand. Tennessee is one of the non-expanding states at this point. And then John mentioned that there's a question about whether subsidies accrue in states that have not established their own exchanges. And so the four elements of the basic architecture of the Affordable Care Act is expansion of Medicaid. We see that's now controlled by states. The individual mandate, subsidies on state-run exchanges, and then the large employer mandate. Well, numbers 3 and 4 are potentially subject to states as gatekeepers because the subsidies are, if the plaintiffs are right, and I suspect that they will be vindicated by the Supreme Court decision that's going to be handed down by the end of June, then if the states don't set up their own exchanges, then there will be no subsidies in those states. And since the subsidies trigger the large employer mandate, there will be no large employer mandate in those states if the plaintiffs are right. And so this gives an enormous gatekeeping role to the states as part of the design and structure, at least as it's turned out in the Affordable Care Act. Now, I think the most constructive part, there are many good things and some not so good things in my view about the Affordable Care Act, but one thing that I view as the most important is the intellectual conversation that those of us who for years have been talking about cost containment in medical care were seen as the green eye shades people. No one wanted to hear us. No one wanted to listen about cost containment. But guess what? In the Affordable Care Act, half of the Affordable Care Act is paid for by reduction in costs in Medicare. And so Medicare's drawdown, now of course the advocates will say that is no drawdown in benefits, it's only pulled out of the hides of the providers, the hospitals and the pharma companies and so forth, but next time you see your doctor, you'll somehow see that 20-minute doctor visit is now maybe 15 or 10 minutes. The things that doctors used to do are being done by nurses. So this notion that there's no benefit impact is wishful thinking. And so we now see that there is a link. And what I've always argued is that cost containment should really be seen as either or rather than yes, no. Typically, we see these cost containment decisions as yes, no. And even for the toughest cost containers like me, it's pretty hard to say no to someone who's coming with a non-frivolous, serious claim for benefits. But when you look at these issues in either or terms, it's a lot easier to say, well, if I say yes to you, that means I have to say no to somebody else. And that structurally changes the conversation in important ways. And so the Affordable Care Act recognizes the either or perspective rather than the yes no perspective. And that is to say that if we are going to cut back on Medicare some, that means we can afford to pay for a lot of folks who don't have access to medical care, and therefore we're expanding benefits. So I think that is, from an intellectual point of view, the single biggest contribution of the Affordable Care Act is that it really treats cost containment as an access to care issue. And it shows that restraining cost allows us as a society to improve benefits and improve access to care for a lot of folks who haven't been covered. I want to talk now about, and Leah set the framework for this, of conditional spending programs, which are typically called cooperative federalism programs. Cooperative federalism programs are, just as the name suggests, are programs that where the federal government puts out some money and pays for services that are typically delivered through the states, usually with some cost-sharing obligation on the part of the states, but not always. Sometimes there can be block grants and so forth. I view as the single most important contribution of the NFIB, the state's challenge to Medicaid expansion, is the clear notice requirement. And I'm going to do a quick run through and then go back in more detail. In a case from 1981, 30 years ago, the court held that in order for states to be bound by terms and conditions, those terms and conditions have to be specified unambiguously in the beginning. That states have to be aware of what it is that they're buying into. They can't be expected to buy a pig in a poke. And the focus, the right focus in the Arlington case held this, is the perspective of state administrators or state officials who are determining what is expected of them. Can they reasonably be expected to know what is expected of them in some sense of foreseeability? It's important to restrain federal power. Again, as Leah said, that these dollars are not unconditional, they're conditional dollars. And this clear notice rule has both what I call a positive and a negative effect, and both of which were referenced in the Chief Justice Roberts' opinion. First, there's what I call a positive effect to inform state decision-making so that participation in these federal programs is based on a clear understanding of the bitter as well as the sweet. So it's often easy to be put on your rose-colored glasses and say, oh, all this federal money is coming to us, or to use the term that was discussed, boatloads of federal money are coming to us. It's very easy to talk about the sweet, but basically often the conditions from the state's point of view are bitter in the sense that it requires ponying up money or raising taxes or doing something that is a state obligation. And so in order to justify the sweet, the state has to be aware of the bitter so that that factors into the decision-making process. Then there's the negative aspect of this clear notice rule, and it guards against ex post blindsiding, or what the court calls post-acceptance conditions. And this avoids a federal bait-and-switch tactic. So the key issue regarding the Affordable Care Act with respect to clear notice is, when does this notice requirement accrue? Does it accrue when the state initially signs up for the program? And I'll, in a few minutes, talk about this notion of contract formation. But when the states sign up for the program and they form the contract between the federal government and the states and they set up the deal, is that when the notice has to accrue? Or is it enough that the notice accrue when this contract that's already been set up is then modified and there are changes in the terms and conditions? This is an issue, I must say, that I brought to the table that was not brought to the table before. The states barely mentioned the Pennhurst case from 1981. I view that as a central case in this. It was in the case itself, the states barely mentioned Pennhurst. But I think the Pennhurst case is the important one here. Then there's a leveraging problem with these cooperative federalism programs. There is an analogy to contract, and that these programs are contractual in nature. Again, this is a contribution, an important contribution from the Pennhurst case in 1981, where the court held that the relationship, the dollars spent by the federal government and the dollars received by the state governments with conditions, are in the nature of a contract. That's the best paradigm or model for what's essentially a voluntary program, that you enter into something voluntarily, and it's a contractual relationship. Then the question is, and again, this is something that the brief that was referred to talks about in a lot of detail, is that there is a difference in contract law between how courts review the formation of a contract and the modification of a contract. And so this is the leveraging problem. Medicaid is being expanded, but if states didn't choose to accept that expansion, then they lost their pre-existing Medicaid. And so this was certainly a modification, and a substantial modification, of the original Medicaid deal, the Medicaid contract. And so how do you get the right narrative or the right allegory? And the Alaska Packers case is a 100-year-old case that I think audiences, expert and lay, can really understand. And here's what was happening in the Alaska Packers case. The Alaska Packers case involved a shipping vessel, a fishing vessel, and the fishing vessel left shore to go out on catch fish. That was its job, that was the business, and they had sailors on board who'd agreed to a certain wage. They got out into the middle of the ocean, or into the fishing waters, and the workers, the sailors, said, we're not going to do our job unless you raise our wages considerably. And the owner of the boat was really dare I say, in a pickle at that point, because the whole purpose of the voyage was to catch fish, and all the expenses that had been accrued would have been for naught. And so they agreed under duress, and then they came back to shore and challenged the validity of that. And the court, the Ninth Circuit, said the sailors were free to negotiate on their wages before they left shore. But once they were out in the middle of the ocean, this was a modification of the contract, not the original formation of the contract, and they had too much leverage. And therefore, the court would review and enter into the fairness of that transaction and the substantive fairness of it. And the court concluded that that was just totally a holdup and refused to enforce that contract. In my view, that's really what the Affordable Care Act was with respect to the expanded Medicaid, is that the states were locked in, and the idea that somehow they could give up Medicaid was just totally unrealistic. They were like the owners of the boat, and that they were being held up by the sailors, in this case by the federal government. There's also an accountability problem, because who was breaking trust with the original Medicaid deal? Part of the concern that the courts have expressed is to locate political accountability. And so in that case, is it really the states that would be blowing up Medicaid, or was it the federal government that was saying with these new terms that seem to be attractive, or why is this not attractive, and that the states are blowing it up, or is it the federal government blowing it up? In my view, it was really the federal government that was blowing up the original deal by adding on these extra terms, and yet the states were in the position for having to absorb the political flack that went along with it. And so the idea that there was not coercion is belied by the fact that nearly half of the states have not gone forward with expanding Medicaid, and some very large ones like Florida, Texas, and even Tennessee have not gone forth, Wisconsin and a bunch of other states. There's, as I said, almost half of them, and states like New Hampshire, I just learned, did this, but only this year. Okay. Medicaid programs, these cooperative federalism programs, also breed a lock-in effect. Once the states are on the program, lots of interests develop, provider interests, pharmaceutical companies, beneficiaries. It's really the alliance between the provider community and the beneficiary community, and it becomes extremely painful to undo a program that's already in place. And again, what I've called the problem of political moral hazard is that it's a lot easier for the states to be spending federal money, and then once that happens, once it's locked in, it becomes extreme. The history of Medicaid has been that there's incentive for states to get in easy. It's kind of like a narcotic. I've called it a political narcotic effect. It's easy to get hooked. And then once you get hooked, the states kind of raise the floor, and they raise the conditions and so forth, and put tremendous pressure on the states in that regard. And so in the beginning, the states drive the federal budget by increasing and expanding the program, and there's a displacement of political accountability as a result of that. And then once the states are locked in, then the feds raise the floor, and they drive the state budget. And so you have a mismatch of political accountability. It's a whipsaw. And so I started off my work on cooperative federalism thinking that it was really not a bad idea to expect the states to put in a little bit of skin in the game, but I've really changed my view about this because of this lock-in effect and the political moral hazard. Now, I want to turn to the state autonomy. I don't see a clock here, so I'm going to have to, I don't know if I'm behind time or not, but there's a state autonomy issue. Part of the idea of the contract model is that states have a right not to participate in these federal spending programs. This is the anti-commandeering principle that the Supreme Court announced in New York versus United States. It's a principle that really goes back to Martin against Hunter's lessee at the very founding. But the Supreme Court in the modern context has given effect to this in New York versus United States, and then a case called Prince, P-R-I-N-T-Z, versus United States. The anti-commandeering principle developed in the context of the Commerce Clause and was a formal principle that said the federal government cannot force states to do things, including setting up an exchange. The question here is whether this anti-commandeering principle applied in the spending program, and importantly, NFIB held it did. not in a formal sense, but in a functional sense, that there was a functional counterpart to anti-commandeering that applied in the spending case. And the doctrine goes back to cases like Dole and earlier cases where the court had used the term coercion, but what the coercion context really means is it's a form of the anti-commandeering principle measured in functional realities. So what does the Affordable Care Act do? And I can go through this pretty quickly. It links the expansion of Medicaid to pre-existing Medicaid programs. It's a form of leveraging on the states, requires states to cover all persons up to really 138% of federal poverty because of the 5% income disregard. And the states were faced with the choice of either expanding Medicaid or losing their pre-existing Medicaid entirely. There's a separate financing measure, so this is a special kind of Medicaid. 90% federal match after a phase-in period, 100% in the short run, but 90% over the longer run. Applied only to newly eligible enrollees, and when you talk to Medicaid administrators, they're worried about the woodwork effect. Folks who were previously eligible for Medicaid but had not signed up, they're not eligible for the 90% match. They're eligible for the traditional match. And so if you increase the number of previously eligible people for Medicaid and they come out of the woodwork and they sign up, the state doesn't get the attractive new match, they get the less attractive previous match, and that's a big factor for many of the states. And also, it's not discussed that only for administrative costs, the matching formula is much less attractive from the state's point of view. So what are some constitutional constraints that are critical here? These are cooperative federalism programs. They're voluntary for the reasons I've discussed. The states cannot be forced to enter into those programs. They cannot be commandeered. States can be bribed. They can be induced, that's the nicer word, to enter into a cooperative federalism program by attractive terms and benefits, and that's really the deal. But voluntariness must be assured. And in order to protect the voluntariness, the court in 1981 in the Pennhurst case adopted the clear notice idea so that this would be a voluntary decision to participate in these programs, and that the states had unambiguous notice of the terms in advance. This clear notice rule protects the integrity of state political decision-making, allows states to evaluate in advance the pluses and minuses of voluntarily signing up for a federal spending program, and it also guards against the imposition of ex post or after the fact blindsiding and these bait and switch tactics. So what is at stake in the NFIB case, and the ACA expanded Medicaid case? The question is, when does the clear notice rule apply? That's really the question. The states didn't raise that much, and if you look at a footnote in Justice Ginsburg's opinion, you'll see that she criticizes the court and Chief Justice Roberts' opinion for focusing on this clear notice when the states didn't really raise it. Well, somebody did raise it. And the court raised it and really relied upon this part. And I think that this is really the most important part, even though it wasn't really discussed very much in the overview or in the commentary. I think that the clear notice aspect of this case is under-recognized and yet singularly important. Does it apply when states sign up at contract formation, or does it apply when these new terms are out there? And the argument for the government was, well, gosh, the states had 3 years to know what to do about this, and they had clear notice. But that really doesn't answer the question of what the clear notice rule is designed to do. And clear notice is designed to protect against after-the-fact blindsiding and to protect the states when they sign up so they know what they're getting into. They're not buying a pig in a poke. In this case, the Affordable Care Act built on traditional Medicaid, and it modified the original terms in substantial ways. And ultimately, the question is it enough that the states had this notice before they agreed to modify the contract or form this, as the court ultimately said, a new contract? It was so different that it was a new contract. Or do they have to have notice at the outset? The Social Security Act, this is number 3 here, allows for amendments to these programs. And so the question is, can the federal government reserve its authority to change Medicaid unilaterally by putting in a statute that says we reserve the right to change these terms unilaterally? And the court said, no, that's not consistent with the clear notice provision. The clear notice provision is designed to protect the sovereign interests of the state, and it's a non-waivable provision. So the fact that it's in the statute, Tom P., tough luck. The state cannot be expected to waive its rights to clear notice. So what does the court hold here? The court upheld the new ACA terms regarding expanded Medicaid, but the court, as was said before, but the court held that the states could not be threatened with the loss of the pre-existing Medicaid and allowed this to be seen as a new contract, formation of a new contract, and the states are free to enter into this new contract or not without the threat of having to lose the pre-existing Medicaid funding. So the court holds that the clear notice rule applied when the states signed up for Medicaid at contract formation so that the states could not be threatened with the risk of loss to this ongoing program. The original Medicaid program can be modified, and I argued this in the amicus brief that I filed, if the modifications are not substantial and if they are foreseeable. And the court has held this in other cases. If there are terms that were implicit in the original Medicaid, then you don't need notice of every change as long as it was foreseeable and not substantial and within the rubric of the original Medicaid. And Nicole is going to disagree with me on whether this was really part of the original Medicaid, and so that's fine. I mean, that's ultimately one of the issues that the court had to decide, and as you heard, her brief was cited as well, and very well done and very influential. But we disagree on that very important principle. That this was really, so it's not every change that has to be subject to original notice, but it has to be change that's so substantial it could not be foreseen, and it was not part of the original rubric or framework as to the point that this is a modification that's substantial and unforeseeable. And the federal government cannot reserve these unilateral powers to change programs without affording the states unambiguous notice when they sign up of what the terms and conditions are, so that the voluntariness of the states must be protected and there must be guarding against bait and switch tactics. Okay. Now, what could the federal government do? You have to develop a theory, because you can't expect that the feds must maintain Medicaid. And there's nothing in the NFIB case that says the states have to keep Medicaid. So the federal government can repeal Medicaid entirely. It could then reenact Medicaid with the new conditions. This would point the finger of political accountability at the federal government for terminating traditional Medicaid. And Chief Justice Roberts actually addresses this problem, this issue, which appeared in an article that Glenn Cohen and I did in the New England Journal of Medicine. And Justice Ginsburg picks up on this point as well. But this would preserve political accountability. It would be very clear who was doing what. The federal government was repealing Medicaid. Could the advocates for this really say, we're going to repeal Medicaid in order to provide greater coverage for those with incomes under 138% of poverty? It also would protect states against inaction. Failure to act would mean no Medicaid benefits, but under the ACA, states' failure to act meant no qualification for federal subsidy, but still there was a legal obligation to pay for the existing enrollees at state expense. So if the states didn't act, they were out of compliance with Medicaid, and they were still obliged under state law to pay for those Medicaid eligibles, and therefore 100% of the cost of Medicaid would have been on the states if they didn't act. And under the anti-commandeering principle, non-action cannot have these kinds of negative consequences. Okay. Now, the coercion issue. I've talked about the anti-commandeering principle. The federal government can induce states to act through financial incentives, and conditions can be attached as long as they're not coercive. That is to say, they're not akin to this commandeering. And the Supreme Court held in the NFIB case that the imposition of these new terms on Medicaid and enforcing those terms by threatening the loss of pre-existing Medicaid deprived the states of any real choice. So here the intellectual move was to say the anti-commandeering principle, which under the Commerce Clause had been a formalistic principle, was really the operational meaning of coercion in the context of the spending clause. Okay, I'll wrap this up. And so that basically is what the court held. And so what are the factors considered about coercion? The most important was the sheer size of Medicaid, and that's why I think the clear notice is the most important part of this case. There aren't going to be many other situations that are Medicaid size. The context that this was contract modification, the importance of leveraging, and I've talked about the Alaska Packers case. I think the inaction distinction that I've just talked about is important. The right of states not to act must be preserved here. The right of non-action would have been catastrophic financially for the states. And then the structure of the ACA. This is when I turned against this provision, actually. You can find that I participated in the New York Times symposium, and I was sympathetic to the ACA. And then I realized one of my research assistants corrected me about how to interpret the law, and then I turned against it. The subsidies did not range from 0 to 400%. They only ranged from 100% to 400%. So it's hard to imagine the federal government subsidizing folks from 100 to 400% of poverty and omitting those who are not on Medicaid but under 100% of poverty. Clearly, there was an expectation that the states would all expand Medicaid and that these folks would not be left out. And when I realized that, this could not have been anyone's realistic expectation that the states had a real choice here. This is totally irrational as a matter of choice. And finally, the political accountability point. It's the states who would have been creamed politically if they opted out of pre-existing Medicaid. Yet the terms of the original deal were being changed by the federal government. And the finger of accountability should be pointed at the federal government, and therefore that's exactly what the court did. So what's the outcome? As we know, states may choose whether to extend Medicaid. They may choose not to extend Medicaid without the fear of losing their pre-existing Medicaid funding. The law was not declared unconstitutional. In fact, there was nothing unconstitutional about the law. The new Medicaid was held valid as long as it wasn't linked to leveraging on pre-existing Medicaid. And this decision on Medicaid is now entirely left up to state decision-making. It's a new program, like a new contract. And it turns out the federal government has made this an all-or-nothing proposition for the states. I'm guessing now there may be some little more flexibility about the all-or-nothing provisions, that the feds may be more reasonable about that, but given the elections that we've had. But that's one pathway, potential pathway forward. So it's an interesting story. To finish where I started, it means that the states are now in charge about expanding Medicaid, and if the plaintiffs win in this Kinga case, it means that the states will be in charge of the subsidy and the employer mandate. Tremendous gatekeeping role for the state governments. It's a great story of federalism. I'm not sure anyone saw that that was going to happen when ACA was originally enacted, but that's the reality of where we are now. Thank you very much. Now, I have to figure out how to turn this off. Nicole, can you figure out? I'm sorry to leave this with you, but
Well, many thanks to John for having me here today, and to Deli for all of her great organizing, and to all of you for having this wonderful series. I'm really glad that UNH Law is taking the task of civic engagement seriously. I agree with Justice O'Connor that there's a serious lack of civic education in the country right now, and I find that as I teach my constitutional law students, they often say things to me like, I'm not sure I've actually ever read the Constitution. And I say, well, that's why that's your first assignment in this class. So I think that it's important that we engage in these conversations from a basis of knowledge rather than ignorance. So thank you very much for facilitating that. I also always enjoy the chance to have a conversation with Jim. Jim and I are probably two of the few people in the country who anticipated that the Supreme Court would take up the Medicaid portion of the show when the ACA went before the court in 2012, because not too many people actually do healthcare law and constitutional law and can say that with a straight face. So thank you also for the opportunity to engage with Jim, who's one of my favorite people. And finally, I would like to say that you get the sense from this conversation so far that the states are sort of like Homer Simpson, and Congress is more like Mr. Burns. And I just don't think that's right. And I'd like to tell you why that's so. And so what I'm going to do today is talk a bit about some constitutional and some statutory history that pertains to the ACA litigation. I'd like to talk just a little bit about the outcome of that litigation, because you've heard a fair amount about that already. And I'd also like to talk about where we are now that the Supreme Court has inserted itself into the democratic process. And so that's sort of the map for today, and I look forward to your questions, which I'm sure will bring out many important aspects of this conversation that we haven't talked about thus far. So, what does the Constitution tell us about spending? And as you may be aware, this is a famous painting that is supposed to depict the actual writing of the Constitution. And often in constitutional questions, we like to think about what the framers might have intended, even though it's questionable whether the framers themselves wanted us to think about what the framers intended. And so we've heard about what we call the spending clause, Article 1, Section 8, Clause 1 of the Constitution. But the spending clause doesn't actually use the word spend, as you may have noticed before. It tells us that Congress shall have the power to provide for the common defense and general welfare of the United States. And Article 1, Section 8, Clause 1 also gives Congress the power to tax, but it was a limited form of taxation. Now, at the same time that Congress was given its enumerated powers, we also got the 10th Amendment, which is at the heart of the debate that we're talking about now, because ever since the Supreme Court has taken on the task of interpreting the 10th Amendment, which tells us that the powers not delegated to the United States by the Constitution or prohibited by it to the states are reserved to the states respectively or to the people. Well, first of all, that last phrase is just read out of the 10th Amendment, so don't worry about that portion of the show. But beyond that, there's long been a debate as to whether the Supreme Court should intervene in the relationship, that tense relationship that's set up between Congress and the states. Congress is given certain enumerated powers. Those enumerated powers are enhanced by the Necessary and Proper Clause, which tells us that Congress has the ability to act beyond those enumerated powers, at least in certain circumstances. And then the 10th Amendment tells us that if it hasn't been given to Congress, it remains with the states. Sometimes the Supreme Court has said, this is but a truism. It's just a reminder that there's this relationship between Congress and the states retain what hasn't been given to Congress. Other Supreme Courts, depending on the sort of tenor of the court, if you will, and the justice leading the court, have told us that it's the court's job to police that line between Congress and the states. We have been living through two Supreme Courts now, the Rehnquist Court and the Roberts Court, are courts that have told us that it is the Supreme Court's job to police that line. And that's part of the debate here, writ large, in the ACA litigation. Whose job is it to make these decisions? Where does the power lie? And is it the job of the Supreme Court to police this line? If so, what does that mean? I would posit what it means is that the court is actually aggrandizing its own role in what might otherwise be legislative or elective branch questions. Finally, what I'd like to mention to you is a provision in the Constitution that doesn't get discussed very much, but that is important for understanding the history of the spending power. The 16th Amendment made it so that Congress had the power to have an income tax. And so it wasn't until the 16th Amendment was passed in 1913 that Congress actually had enough money to do much with its spending power. And so we don't even really have any spending clause litigation until 1936 when Butler is decided. So there's no deep history here the way that there is with certain other provisions in the Constitution. This is all modern history, at least in constitutional terms. So just to give you a sense of what our first Congress was looking at, the appropriation statute for 1789 for the first Congress gave $137,000 to the War Department, $190,000 to discharge old Treasury warrants, sort of in the tenor of our prior panel, which was excellent, and thank you for that. $96,000 for veterans' pensions, $216,000 for defraying the expenses of the civil list, which is basically everything else. And the president gets this discretionary fund in the next year in 1790 that is about $10,000, and that caused quite a ruckus. So just to give you perspective, the Medicaid program cost roughly $400 billion last year. We're talking about wildly differing standards and possibilities. The first Congress, the framers of the Constitution, they couldn't have contemplated the things that we're talking about now. The most powerful weapon was a musket, which I could dodge in my sleep, okay? So when we think about what the framers would have thought about these debates, the truth is they wouldn't have thought much about the spending power because there wasn't much to say about it at the time the Constitution was written. However, it is important to remember that in part the Constitution was a response to the Articles of Confederation, which did not create a strong enough centralized government. And so Congress did need power to spend so that it was not at the mercy of the states in creating a strong enough centralized national government. So there are reasons to understand that the spending power is an important standalone power for Congress. Now, another question that I think often comes up in this context and hasn't been addressed yet today is whether there's a constitutional right to health care. Now, of course, the answer to that is no, unless you're a prisoner, in which case the Eighth Amendment tells us that that would be cruel and unusual punishment to withhold health care from you. So for the rest of the country, there is no right to health care. Well, okay, so think again about context. Why is that so? This painting by Eakins, which is a famous painting about the operative theaters in the late 1800s, postdates the Constitution by 100 years and already looks barbaric to us. So if you think about what was happening at the time the Constitution was written, what we're really thinking about is, oh, bloodletting, leeches? I don't think I want to write to that, thank you. And the framers didn't even think about it. So healthcare is not a right that's written into the Constitution. Nevertheless, Congress has responded to this deficit in a number of ways. And so that brings us to thinking about the nature of statutory rights, which are often created in response to deficits in the Constitution and the constitutional structure. And so as you may be aware, this is President Johnson signing Medicare and Medicaid into law in 1965, with President Truman sitting right next to him. He was the first enrollee in Medicare, as you may know. And so the question is, what happens with these statutory rights when Congress attempts to modify them in ways that don't comport with their original design? Do we try to treat this like we treat the Constitution? Do we try to understand that Congress has the ability to modify its own laws? Do we try to understand that time changes all things? Historically, the states were responsible for medical care, welfare, and medical welfare. But over time, that has changed. Incrementally, that has changed. And I would posit to you that the ACA is really the big tipping point in that. Because up until that point, although the federal government had enacted important laws that federalized healthcare to a degree, the ACA really, in many ways, is a federal takeover of healthcare law. One other thing I'd like to say about this slide before I move forward. Some of you may be sitting there thinking, gee, I have a hard time keeping Medicare and Medicaid straight. Fair enough. The justices also have that problem. So here's an easy way to remember it. Medicare, care for the old. Medicaid, aid the poor. And there's a big difference between these programs in the context that we're discussing today, the spending power context. Medicare is a pure federal spending program. The federal government takes a tax from your work taxes and turns that money into the Medicare program. It's a centralized spending program. It is purely federal. Now, there are regional contractors who administer the program, but there is no role for the states in Medicare. Medicaid, as you've heard, is a cooperative federalism program. Now, the interesting thing about cooperative federalism programs is that they invite the states to participate in federal law. So the federal government could have kept Medicaid in its own hands, much like it did with Medicare. And in fact, the reason that Medicare is centralized, as you may be aware, is that the AARP very effectively lobbied for that outcome. The AARP did not want the elderly to be left in the hands of the states and to the whims of their economic woes. And so the AARP very effectively lobbied for Medicare to be centralized with the federal government. And at the time, 30% of the elderly were impoverished. So if you look at Medicare from the perspective of, has it played a role in ending the impoverishment of the elderly due to medical care, the answer is yes, because now only about 9% of the elderly are deemed impoverished. Now, of course, our standards for impoverishment are quite low, but that's a different conversation. So Medicare is purely federally funded. Medicaid invited the states to continue to participate in medical welfare. So the federal government took some power away from the states, but then gave some back. And so the interesting thing about cooperative federalism is that it engages the states. This is one of the reasons that I think the court is too quick to jump in when cooperative federalism is on the line. Because the end result may be that the federal government has to operate with greater power rather than less when the court operates in the name of state sovereignty. And I'm going to discuss that a little bit more in a minute. So as you've heard already, historically, Medicaid only covered the deserving poor. There were people who were deemed worthy. There's a direct lineage between this concept and the English Poor Law of 1601. And so you can't say that this is a very distinguished history because we truly were trying to force people to not take government handouts. There was this idea that only if you were blameless for your poverty were you worthy of government assistance. And so that meant pregnant women, children, widows, the elderly, the blind, the disabled. Medicaid built on that structure. And in many ways, it was the caboose to Medicare's train. There wasn't a lot of thought put into Medicaid when it was created. And in fact, again, to go back to that Simpsons analogy, the states asked for more money. Ever since basically the Great Depression, the states had been asking the federal government for money for medical welfare. And they kept asking, and they kept asking, and they kept asking. And over time, the federal government kept giving more and more money to the states. And every time the federal government gave more money in an increment, it decided that it needed to do something more to require the states to actually play by the rules, because the states would take that money and then play games with it. And so Medicaid is in some ways the federal government saying to the states, we're not going to let you play with this money anymore. When we give you money for medical welfare, you have to use it for medical welfare. We're going to create a federal superstructure, and you have to comply with it. And if you don't want to comply with it, don't take the money. Go pay for it by yourself. But of course, the states had been saying for years that they could not. So that was the intentional part of Medicaid, the federal takeover of medical welfare. The part that was less intentional was the deserving poor portion of Medicaid, because the federal government basically took what the states had been doing and federalized it. That was not philosophical. It was not particularly intentional. If anything, I would say it's path dependent. We do it this way because we've always done it this way. And it was the least controversial way to get this law passed. Fast forward to the ACA. We expand Medicaid to include everyone. This is an important philosophical change in Medicaid, because for most of its existence, Medicaid has not covered more than about 45% of the poor in America. So even though we think of Medicaid as being a safety net, it has been a safety net with gaping holes. And so very early in the conversation about healthcare reform and what would be possible in healthcare reform, when President Obama and members of Congress were discussing what could happen with healthcare reform, it appears to me from looking at the legislative history, which is itself somewhat convoluted, and that's a different conversation, that Medicaid expansion was always on the table. Now, part of the reason I think Medicaid expansion was always on the table is that every time Congress had expanded Medicaid over the years, the states always agreed. The states have significantly more power in this relationship than they let on in the ACA litigation, because often they are the drivers of the changes in the federal Medicaid program. Often it is the states that are asking for more coverage and receiving it to the tune of more money and some rules to go with that money. So the Medicaid expansion, as you've heard, made it so that everyone up to 133% of the federal poverty level was finally eligible for Medicaid. This included a change in children's coverage. Children had only been covered, children aged 5 to 18 were only covered up to 100% of the federal poverty level. Now, children from 100 to 133% of the federal poverty level are also included in Medicaid. And as you heard, this includes a package of benefits called essential health benefits that actually derives from a law from 2005 called the DRA. So there are pieces of this package that look a lot like what came before. And as Jim said, this is where we fundamentally disagree. He says, this is new Medicaid. This is a different program. I say, I'm sorry, but it's not. It is very much the same Medicaid. And in fact, over time, the federal government has expanded the mandatory categories of eligibility. And over time, the states have always agreed to those mandatory expansions because they need the money that the federal government's offering. That doesn't mean their arm is being twisted. It means that they're realistic, that they're getting a lot of federal money in order to cover the poor in the state. Because if they don't, as you may be aware, states often cover charity care. They don't cover all charity care, but they do try to help out the hospitals in the state who have to take all comers in the emergency department. And so the states have been on the line for charity care. This is part of the reasoning when you hear people say that the expansion makes a lot of sense for the states fiscally. This is the reason that it makes a lot of sense for the states fiscally, that all of the indigent population that wasn't covered by Medicaid before was an expense to the states, and now it shifts to the federal government. So, as you've heard, 7 justices held separately in NFIB versus Sebelius that the Medicaid expansion was unconstitutionally coercive. No provision of the ACA was struck down. No provision of the Medicaid Act was struck down. Every statute in question in the NFIB versus Sebelius litigation remains the same. So the remedy that the court concocted, I have to admit, I may be partially responsible for this, because I suggested in my amicus brief that the court had to understand the importance of the Medicaid expansion from the perspective of states that wanted the expansion, because federalism cut both ways in this litigation. You don't often hear the flip side of this litigation. But the other 26 states that weren't driving the litigation against the ACA, they wanted the Medicaid expansion. They wanted the money that was being offered. And so federalism meant allowing those states to move forward with the expansion if they wanted to. It wasn't just a matter of honoring the states that were fighting the expansion. So the remedy for the unconstitutional coercion that a plurality of the court found and that the joint dissent agreed with was that the authority of the Secretary of the Department of Health and Human Services would be limited, such that if a state chose not to expand its Medicaid program, that state could not lose all of its Medicaid funding, even though that has been a term of the Medicaid Act since its inception in 1965, and even though the Secretary has never exercised that authority. In the entire 49 years of Medicaid's existence, the Secretary of the Department of Health and Human Services has never withheld all of a state's funding because the state wasn't compliant with the Medicaid Act. So NFIB is very much a continuation of what people call the federalism revolution. This revolution, and I'm not sure if that's the right word, but that's what people call it, was started by the Rehnquist Court. And the Rehnquist Court was the first court in decades to decide that the 10th Amendment was judicially enforceable, that it was the job of the Supreme Court to enforce the terms of the 10th Amendment to protect the states. Until NFIB versus Sebelius, we didn't quite know where the Roberts Court stood on the federalism revolution. There had not been any major proclamation as to where the court stood in terms of enforcing the 10th Amendment. Further, no decision since 1937, because ironically, U.S. v. Butler, which is often cited as the first decision describing the spending power, actually struck down the use of the taxing and spending power in that particular case. No decision since 1937 actually struck down Congress's exercise of its spending power. So NFIB versus Sebelius is a first in a number of ways. It's the first case since 1937 to strike down Congress's exercise of its enumerated power to spend for the general welfare. No prior decision actually articulated the coercion doctrine. And I think this is important to understand as well, because there are a lot of firsts in NFIB versus Sebelius. Another first is accepting this distinction between activity and inactivity in the commerce power, but that's a different conversation. So the first that's the first here is, you heard before about the South Dakota versus Dole case, the case that gave us a 4-part test for understanding conditions on spending. That case tells us that there are 4 ways to understand how Congress can place conditions on spending. So first, the spending has to be for the general welfare. Second, the conditions themselves have to be clear to the states so they understand what they're getting into. Third, the conditions must be germane to the spending. And fourth, Congress cannot place unconstitutional conditions on spending. Coercion was dicta. Coercion was not actually part of this 4-part test. And coercion had been mentioned in passing, but there had never been a coercion doctrine. Well, guess what? After NFIB, although the coercion doctrine is recognized, it still is not articulated, because the court basically told us it knows coercion when it sees it. Now, we've tried that test in the First Amendment, and it didn't work. So this is the first case to strike down spending for the general welfare. It's the first case to articulate a coercion doctrine. And it's the first case to expressly recognize that the 10th Amendment can act as a limit on the spending power. But there are key misunderstandings in this decision. First, the court attributed to Congress a degree of intentionality that I think did not exist. And it's because of this. The court, as Jim said that Congress couldn't force the states to take these post hoc terms, and the fact that it had no backup plan indicates that Congress knew the states would all take the Medicaid expansion. I would characterize it differently, respectfully. I would say that Congress was realistic in understanding that the states had accepted every prior expansion of Medicaid. And so to try to plan for near universal insurance coverage, it was reasonable for Congress to anticipate that the states would accept this expansion as well. It wasn't intended so much to twist their arms as it was an understanding of the history of Medicaid, that every time Congress had expanded in the past, the states were on board. So it was anticipatory, not necessarily coercive. I would also say that there's a misunderstanding in terms of the dynamics between the federal government and the states, because there is a constant negotiation that's going on between the states and the federal government. And we can't think of the states as some kind of black box, as if the states sit over here and they all act in one way, and the federal government sits over here and it acts in another way. Each of the states is driven by different factors and different interests. Those interests were transparent in these negotiations. So think of the Cornhusker solution, right? Initially, Nebraska was going to be the only state that was going to get 100% funding for the Medicaid expansion. But then all the other states said, oh, we want that too. And Congress made it happen. That's state power. The states had negotiating power in the creation of the ACA. And so, for the reasons I've stated so far, I would say that the expansion is not a new program. It is a continuation of an old program that needed some fixing. The statutory remedy that the court came up with is absurd. And here's why. The court told us that this is new Medicaid. This expansion is to this population that's never been covered by Medicaid. It doesn't look like Medicaid. It's a new program. It doesn't look like Medicaid. It's unduly coercive to attach that new program to the old funding for Medicaid. Where did the court find the remedy for this supposed unconstitutional coercion? In the Medicaid Act. So not Medicaid enough for purposes of coercion, but Medicaid enough for the remedy. Which is it? Again, I posit to you, it is all one program under one statute. It is one Medicaid program. So, of course, the Medicaid expansion is rendered optional. One thing that was not possible, because of the way the ACA was drafted, was what some of the states called partial opt-in. Some of the states wanted to know, okay, given that there's this structure where people who are purchasing private insurance can get subsidies in the exchanges, and those subsidies are available for people between 100% and 400% of the federal poverty level, given that structure, can we just expand Medicaid up to 100% of the federal poverty level? Because we know that the people above 100% will be covered by subsidies in the exchanges. HHS had to say no to that because it doesn't have the statutory authority to negotiate in that way. So partial expansion's not a possibility. That's off the table. Subsequent to NFIB, there have been 4 waves of Medicaid expansion. Now, interestingly, each of these waves has shown greater creativity on the part of the states. But here again is where I say, I don't really think that the court did much here that was important for the states, because the authority by which the Secretary of the Department of Health and Human Services is waiving statutory requirements under the Medicaid Act is called Section 1115 demonstration waivers. Section 1115 existed before the ACA. And in fact, the ability of the Secretary to negotiate 1115 waivers existed before the ACA and before NFIB versus Sebelius. So the Supreme Court didn't facilitate anything new in allowing the states to opt in, except perhaps an understanding that they didn't have to accept the Medicaid expansion. But the waiver authority that the Secretary has been using in the wake of NFIB was there all along. So, are the states opting in? Yes, they are. More than the color-coded maps that you'll find online will tell you. Because if you look at the news that's happening in the state capitals, even Republican governors and legislators are interested in Medicaid expansion. Why? Because a huge amount of money sits on the table waiting for them. And because the stakeholders need the Medicaid expansion. Hospitals will start to lose money if Medicaid does not expand. So right now there are maybe 12 states that are saying that they will hardcore not opt in, but I think they will come around. If you have any historical perspective on Medicaid, you understand that it took a long time for the original Medicaid Act to be adopted by all the states. Arizona didn't opt in until 1982. So we have to take a longitudinal view of this, and I would say that looking in the long term, I do think that despite the Supreme Court's best efforts, most states will eventually expand their Medicaid programs. Thank you very much.
Thank you to everybody. I'll shout. Thank you very much to all 3 of you. That was excellent. In the interest of time, I think we should turn right away to audience questions, if that's okay. And I'm sorry, I don't have a working microphone, so if people who would like to ask questions, I'll call on people, and if you can project your voice as loud as possible, that would be very, very helpful. I should note, too, that because we're going over time, people may need to sneak away, and I know even some panelists are facing time constraints. So don't be shy if that's the case. Oh. Okay. Would anyone like to go first while we're getting the microphone?
I'm just curious if Nicole can tell us the 12 states.
Yeah, so.
Can you repeat that?
question?
Delhi was wondering what
What the 12 states
or at
are.
least some of the 12 states that
Yeah,
are-
so it's
are-
basically the Deep South. So Texas, Louisiana, Mississippi, Florida, Georgia, South Carolina, and that's really the hardcore ones right now. I think Texas will probably be the holdout this time around rather than Arizona. Because even some states like North Carolina, which originally said they were absolutely not going to opt in, had conversations at the National Governors Association annual meeting this past summer with the new Secretary of the Department of Health and Human Services, who apparently convinced the governor of North Carolina that expansion might be a good idea. So the states are coming around slowly, and even in those states that have taken a hard line, there are effective lobbying efforts going on that are slowly changing minds. I thought for sure that the Ebola outbreak would change Texas's mind, but I think it's hard to change the Texas mind, so.
Yeah, and I agree with Nicole that over time more states will opt in. I think that this election is likely to change the terms of the deal that the states will be able to cut, and if not in these 2 years, then with the next administration. But I think that the holdout states are holding out for a better deal, and with more flexibility in Medicaid. Medicaid, when I was doing Medicaid reform, the bane for the states is the inflexibility that they feel that they face in Medicaid. And so I think you're going to see requests, whether it's waivers or whatever, more flexibility, maybe some relief on EPSDT and other kinds of expensive programs.
So one dynamic that's at play here is something called horizontal federalism, which is the idea that the states learn from one another how to exercise their power. And you see that really writ large in the Medicaid expansion dynamics right now, because each of the states that has been opting in recently has clearly been learning from the waivers that prior states have obtained. So Arkansas was the first state to obtain a waiver to place its Medicaid population, its new expansion Medicaid population, into the exchanges. And those people will be paid for by Medicaid funding, but they'll be placed in the exchanges and their premiums will be paid for by Medicaid. So after Arkansas, you had Iowa and Michigan, and then Pennsylvania. And Pennsylvania tried to get a work requirement placed into its expansion, but HHS had to reject that, of course, because this is not a welfare program, and we don't place work requirements in Medicaid. But Utah is still looking to get some kind of maybe work training requirement placed into its waiver. You might have noticed that the governor of Utah just a week or two ago was sort of crowing that he had gotten some deal worked out with HHS. But of course, they still have to submit their waiver application, and it has to be reviewed under the terms of the law. And it's my understanding, coming from a conference that I was just at, that Cindy Mann, who's the administrator of the Centers for Medicare and Medicaid Services and is responsible for all of this, is very aware that the expansion is universal, in that we are no longer judging people based on whether or not they are worthy of assistance. And so while we want to get lives insured, that doesn't mean that you do it at all costs.
I think I heard two strategic concepts sliding by here, and I'll just point them out and see what the panel has to say. One is the idea that as a result of the court's intervention between the feds and the state, Medicaid, which was a collaboration with the states, might have been more successful if the feds just took it over entirely and pulled it out of the states and eliminated the states' rights in that area altogether. The second observation is that the arguments being made that the court seems to have accepted about prior contract and the commitment that the government has to upholding that now means the government has to uphold ACA because that is now the contract with the people and with the states. So any attempts to change ACA will be influenced by the prior contract arrangement. So I'm wondering how that affects ongoing discussions.
Yeah, so as to your first point, I mean, that's the irony of the decision, right? It would be much easier for Congress to have taken over Medicaid and not to leave a role for the states in the program. It would be more costly because the states do bear some expenses in Medicaid. But centralizing Medicaid is constitutionally more straightforward. So yes, as to your first question. I don't know if you want to address the second one.
Yeah, I think a centralized model would not face the same constitutional problems. But Medicaid was really designed, and this is where Nicole and I have different viewpoints about this, but the Medicare was a medical program linked to the Social Security income support program. Medicaid was really historically quite an afterthought. It was Wilbur Mills developed this in with very little of the same kind of forethought that went into Medicare, and it was linked to an income support program at that time, aid to families with dependent children. So each was a medical benefit linked to an income support program, and so I think it has two different origins, and it's easy for us to say here that there's going to be a linkage. I think that's just not going to happen. From a constitutional point of view, it would have been easier. To me, that's why Medicaid was seen as poverty medicine, and the court's view, and again, this is where we disagree, but I think that from the court's point of view, when the state signed up for poverty medicine, that didn't mean linked to AFDC. That means that they couldn't reasonably have foreseen expanding without the categorical restrictions and to 138% of poverty, which is well above any notion of poverty medicine. And so as part of a cornerstone of the affordable universal coverage, and that was, the court called it a new program, I call it a substantial modification of an existing program. It's the same thing, that you need to have new contract formation, and that's what we have now. And so the remedy that was adopted was the requirement that the states be treated as opting in rather than opting out to a new program, and that changes the pre-existing status quo. If you have to opt out, all the politics is on you. If you have to opt in, it's a different political dynamic, and therefore the states that have not opted in are not subject to political challenge. They really are the ones who are saying, okay, we're going to take it or not take it. There's plenty of political pressure from the hospital associations and pharma companies and so forth to move to expand Medicaid, but not at the risk of having those states say, oh, well, you're getting rid of our pre-existing Medicaid. This is a new deal, a new contract, a new set of discussions, and the states are not at risk politically for at least giving up their pre-existing Medicaid. And the dynamic is entirely different. I mean, I agree with Nicole that over time more states will opt in, but I think the terms will change if there's a new administration. All these notions that it's either opt into 100% or not, all of those are waivable. And I think you'll find, and this notion of devotion to universal coverage, if there's a Republican president, there'll be less devotion to that principle and more flexible negotiating. So I think for 2 years, there's going to be some limitation. It depends on how much the Obama team really wants to cover more people, or they want to maintain this ideological position that the ACA changes everything. But after 2 years, those issues will diminish in importance, I think.
Speaking about universal coverage, what would be the legal ramifications for such a plan? And you know, if you could sort of put your hat on and sort of think through that, how does that all happen? I mean, that's an ongoing conversation, but I'm kind of interested to know, how would that work? How, in your mind, how could that work?
I'm sorry, can you say what the that is?
Oh, how
Universal
could universal coverage, you talked about, how could universal coverage occur given, you know, the legalities that you've talked about?
Well,
You mean like a single payer plan? Is that what you mean?
well, if you're directing that at me, constitutionally, the single payer plan would not pose the same kind of constitutional problems, but there are tremendous political problems. The president's group had 60 votes in the Senate and huge majorities in the House. They couldn't push it. They couldn't get 60 votes. I don't see the Dems having 60 votes anytime soon again. I don't see the Republicans having 60 votes. I just think the country's too divided. That was a one-time deal for 2 years. And even under those circumstances, there were not 60 votes for a single-payer universal plan. Now, there are pluses and minuses with this. There are many fans of that, and there are many problems with it around the world. So I don't see there's a constitutional problem. I think there's a political problem.
But from a constitutional perspective, it's actually fairly straightforward. It's basic, pure federal spending. we choose what we're spending our money on, and we could choose to spend our money on a single payer plan. And that would be more straightforward than Medicaid. It would be more straightforward than the premium subsidies and the exchanges. It would be more straightforward than the tax benefits that employers get to provide privately based health insurance. It would be more straightforward than this hodgepodge patchwork that we have right now, for sure.
Right.
But the politics of it are a different question,
Yeah,
as Jim said.
I used to say that with respect to these grandiose plans for health planning, that all is great, but not for the United States. And I think the same thing is true, that in foreseeable terms, that's not going to happen. Now, it may be that things have gotten so bad, at some point, the pressure on the system will lead to that as a solution. I don't want to say never, but not in the foreseeable future. And I think this last election certainly cuts in a very different direction. The 2010 election does as well. I just don't see that realistically happening. There was a 2-year window with President Obama's election in 2008 where they had 60 votes in the Senate and a huge majority in the House. And it passed in the House by what? In single digits, I think 7 votes or something, even with a huge majority, and with a lot of arm twisting, and they couldn't get the 60 votes in the Senate. So I think that there's, as a practical matter, that's a vision that is more abstract than real, given our traditions and the importance that we have assigned to federalism values and local values. Every time I grew up in New York, lived in Tennessee for many, many, many years. I think people who advocate this haven't lived in Tennessee, haven't lived elsewhere, to realize that there's a world of difference in perspectives in this United States of America. We are united on certain things, but we diverge on many other things. And I think this notion of one size fits all is not going to happen here, for good and substantial reasons.
I wonder whether you could say, each of you could say a little bit more about the judicial review piece of this. It was alluded to in both your talks. This question, we talked in the first panel this morning about there are many constitutional disagreements, constitutional disputes for which there is no solution in the judiciary. And Nicole, you alluded to a long-standing argument that policing federalism in this way through the power of judicial review is not appropriate. That the court looks like it's intervening on the basis of political terms, and that it really ought to let this sort of dispute between the states and the federal government play out in the political process. And I guess my question is, do you think that both of you disagreed a little bit about the relative strength of the states vis-a-vis the federal government in connection with this particular issue? Should that inform the decision whether the Supreme Court should get involved, or do you think is the better approach for the Supreme Court to just stay out of enforcing federalism limits, stay out of enforcing the 10th Amendment?
That's the question, isn't it? I mean, the Supreme Court hasn't been able to decide on this, and I'm not sure I can either. My impression is that the Supreme Court tends to police that line and grow its own power when it does so. Right. And I think that if it is going to police that line, then it needs to hew to the idea that when it's reviewing questions such as this, economic, social welfare questions, for which it typically engages in what we call rational basis review, that it actually should engage in that kind of review, which is this a legitimate governmental purpose? Is the law rationally related to that legitimate governmental purpose? And of course we have the overlay here of South Dakota versus Dole, but it doesn't take away that rationality question. And the court went beyond what Congress said its purpose was in this law. And in fact, I think substantially got healthcare wrong in the plurality and the joint dissent. They just didn't really bother to get the healthcare parts of it right, because they didn't adopt the arguments being made by Congress, which is typically what they ought to do if they're only engaging in that minimal level of review. So that's where I start to question what the court was doing.
Yeah, let me respond to that. There has been a long tradition of whether the limits on federal power encroaching on states is judicially enforceable. That's the question you're asking. And certainly there's been a yo-yo effect. In 1941, I guess it was, in Darby, the court said the 10th Amendment is a truism. Nicole had that on her slide. Then in 1976, the court tried to adopt a restraint by the courts under the National League of Cities against Ussery case, trying to have a balancing approach. The court in the Garcia case 9 years later in 1985 overturned Ussery and said, well, we really don't have a role here. And then back in 1992, the court dusted off an argument that went back way into the early part of our nation, a case called Martin against Hunter's Lessee, which held that there were limits on the ability of the federal government to commandeer the states, that the relationship was one of inducement, not commandeering. And New York versus United States held that, and then eventually Prince, 5 years later, reinforced that. And that's where we are. One of the interesting points is in the state's challenge, the NFIB case, one of the issues that was presented to the Supreme Court when parties sought review was whether the Garcia case should be overruled. The Supreme Court refused to hear that question. They denied cert on that issue. That was in the case. It was put in as a test case to overturn Garcia. The court refused that. So clearly Garcia is still the law, but the court felt that enough work could be done by the anti-commandeering principle, and so the court has said that's a manageable standard, commandeering in the formal sense. The new ground broken by the NFIB case is to say, well, we're going to add a functional or practical element to commandeering, where the states in reality have very little choice. And the context is it's a big program. The context is that the states were punished for inaction, which they can't which cannot be done under the anti-commandeering principle. So if the states had not acted after the ACA, they would have been in a true pickle financially, because they would not have complied with federal law and would have not qualified for the Medicaid support, but they would have been under state law obliged to cover the Medicaid folks at 100% of state dollars. No state could afford to do that. So if this is not commandeering in a practical sense, once you allow for functional analysis of commandeering, it's hard to see what is. Now, that's why I think that Nicole is right on this, is that there won't be very many commandeering cases. That you're not going to figure, but if this is not commandeering, the principle doesn't exist. So this is an easy marker from that point of view. The question is whether there will be many other commandeering cases. I'm dubious about that. There will be other clear notice cases. I think clear notice is really where the new ground was broken. In this case, they will have exportability. And I do think that there will be other cases on the clear notice issue on cooperative federalism.
And John, there's another aspect to the answer to your question, which is that the court actually reached out for the Medicaid issue in NFIB versus Sebelius. The lower federal courts were in agreement that there was no coercion. And so the Supreme Court granted that question, even though there was no underlying question in the lower federal courts. So the court was asserting that it was interested in policing that line. Again, going to the power of the court question that you asked.
Yeah, it's really an inside baseball story about this, is that the lower court that decided the case, the Florida case, had the Medicaid issue before it. And I must say I had some I kept pushing the Medicaid issue and kept keeping the state. They almost didn't petition for cert on that issue, and I threw a little tantrum and helped get that on the cert petition. But one of my best students clerked for the judge, one of the three judges on that panel, and I'd written a friend of the court brief in the 11th Circuit also, and even one of my best star students didn't give that argument much attention. I didn't say anything to him during the case, but after it was all over, I said, "Did you realize I wrote a friend of the court brief on this?" And he said, "Oh, we were quite aware of it, Professor Blumstein, but we decided we were biting off as much as we could chew with the Commerce Clause, and they decided not to go with the Medicaid." In any event, so this issue didn't get any legs until at the Supreme Court.
We have time, I think, for one more, and then we should eat.
Eating's good, so hopefully this won't take too long. But I read yesterday that the Supreme Court accepted cert on a new case, and I don't know all the details of that. And obviously you don't have a crystal ball as to how that's going to turn out. But is there a broad stroke way that you can speak to what's at stake here, or how that might influence the argument you just laid out?
I can certainly talk to that. That's something I've been involved with too. The issue there is, start with the anti-commandeering principle. The Affordable Care Act provides for, in section 1311, it says state shall, it uses the mandatory language, state shall establish an exchange. Under the anti-commandeering principle, the federal government cannot force the states to set up an exchange. So someone who had our basic con law class must have looked at Section 1311, and what I call the OOPS provision said we can't force the states to do this. We prefer the states to do it, but we can't force them. So they set up Section 1321, which said if states don't elect to set up an exchange, then the federal government shall set up such exchange. And but they never went back and changed the language in 1311, so it still says shall rather than may or should or some other language that softens it. But we all recognize that the shall language cannot be enforced because that would violate the anti-commandeering principle. So in the structure of the Affordable Care Act, there is a provision for subsidy for those persons who buy through an exchange established by a state under Section 1311 for a subsidy. There's no counterpart provision about a subsidy for those who purchase under an exchange established by the federal government under 1321, under this OOPS provision. So the question then is, do you look only at that language and do you say, okay, this is isolating one piece of the statute? Do you look at the total statute? To me, there's a lot of water that's being carried under that language on use of the term such, because the idea is that the federal government is establishing such an exchange and it's identical to the exchange. But it's not, no matter how many times you want to say that you're standing in the shoes, it's not an exchange established by a state. It's established on behalf of a state, perhaps, but it's not established by a state. And so I think that it's a statutory interpretation issue. Then the question is, well, there's a reporting requirement that covers all exchanges. And then, but there's nothing in that reporting requirement that mandates anything about a subsidy. It's just not there. And so then the third fallback is, well, you have to look at the totality of the statute, and clearly the intent was to cover as many people as possible. This, I view, is the weakest of the arguments. The Fourth Circuit that's being appealed from, the opinion was almost apologetic, in my view, and it was one of the, anyway, I'll just leave it at that. It was almost apologetic. So that issue is now going to the Supreme Court. And last week I was at Cato and appeared on a program and predicted that this would be taken and so forth. And it has been. I think that the handwriting, I don't like to predict these things, but you've put me in a position to do it, and I've been bold about predicting how the court would take the case when a lot of folks didn't think it would. So I will predict that there are at least 5 votes, and I think maybe more than 5 votes to overturn this. And it's a very different political situation, judicial/political situation. The court is now just being asked to interpret a statute to determine whether the IRS, which interpreted the law to cover all exchanges, not just state-run exchanges, I think that this is not like the NFIB case. This is not a situation where the Chief Justice will worry about using the Constitution to trump the signature legislation of a new administration. This will not be the same kind of confrontation. Courts do this all the time, interpret the statutes. I would not want to be investing in the side of the government at this point on this case.
What's at stake, though, is the subsidies that are available in federally run exchanges, which is in about 2/3 of the states, because many states said they weren't interested in running their own exchanges. They didn't know how, they thought it would be too expensive, too administratively burdensome, fill in the blank. I mean, the irony is some states said, we don't like the ACA, so we're not doing it because we don't want you to tell us what to do, federal government. But then thereby, they invited the federal government into the state to run the exchange on behalf of the state. So they protested, but expanded federal power at the same time. So there's a real federalism conundrum there, right? So what's at stake is the subsidies available on the federal exchanges, the federally run exchanges, and they're in a lot of states. And if the Supreme Court, which frankly is not that great at legislative interpretation, it's wildly inconsistent, doesn't seem to understand how Congress writes laws. There's a wonderful empirical study that my friend Abby Gluck at Yale did, sort of describing how the court doesn't understand the legislative process at all. The problem is that the court will probably see in the statute what it wants to, like it did in NFIB versus Sebelius. And in that case, I think Jim is probably right. They may say, this doesn't hold water. Now, I don't agree with that, but there's a lot at stake in that, because if people don't get subsidies in the exchanges, then technically under the terms of the law, they are not required to have insurance because it's not affordable to them. And so you start to have a crumbling of the universality of the law.
Yeah,
So.
and let me just add
It's fixable, by the way.
Yeah.
It's fixable. but it takes some doing.
But let me add one other point. The Fourth Circuit, which is the case where cert was granted, upheld this, and one of the justices thought that the law should be interpreted to cover both exchanges. The majority thought that it was the deference should be given to the IRS for this regulation. And so in any event, the best case for the government at this point is the Fourth Circuit analysis, and if there's a Republican president, he or she can undo that provision of, even if the government wins this case, under the reasoning of the Fourth Circuit, a Republican administration can establish the end of subsidies on federal exchanges. On the irony of the question of inviting the feds in, perhaps that is an irony, but the problem is the governors really understood that on any matter of substance, this is where there was lack of trust. They thought, and I advised several governors on this, that, and I have not taken a position on expanding Medicaid, but I have taken a position on whether states should establish the exchanges, and that it would be imprudent and unwise. They're expected to finance it, so all the political angst is that they have to raise the money for the exchanges. And if there was anything that went wrong on those exchanges, the finger would be pointed at them. When we had the rollout problems, the fingers were pointed at the federal government, which is exactly what theory tells us, that under accountability, the accountability should be at the federal level. If the states had run the exchanges, as certain ones like Oregon did and so forth, the political problems are accruing to the states. Now also, I must say that if plaintiffs win this case, the conversation will be intensified at the state level. There will be increasing pushes for expansion for basically the states to set up their own exchanges. Here's the way the conversation will go in many of the states. Since the subsidy triggers the employer mandate, you're going to have a business climate issue versus subsidization issue. And the argument, I can just see the argument because I would make this argument, that if you don't have the employer mandate, you're going to have under market conditions pre-ACA, almost all bigger companies had coverage of some kind. They may not have met the standards of essential benefits under the ACA, but you're going to have 3/4 of a loaf, if not a full loaf, and you're going to have a lot more employment and under the circumstances. So I think it's a better deal for the states to have a little bit less generous health care coverage and a more generous economically vibrant state. And I think that that's the argument we're going to see in Tennessee. Remember, Tennessee is actually very much of a healthcare capital. And so my friends at HCA and all the for-profit companies have been lobbying hard to the governor, who was just reelected, to push this forward. The state legislative pushback is the governor is no longer authorized to expand Medicaid. He must get legislation by the legislature to do that. And I think the odds of that happening are not great unless there's a great deal. And it may be that that will happen. But that's going to be the conversation, business climate versus expansion of ACA coverage.
Thank you very much, all three of you, for a wonderful presentation.